Okay, hello everyone, Clark Towson here. I'm the CEO of INTJ Building and the manager of Spotswood Trailers. So in this video today, I'd just like to talk a little bit about my trailer yard, and subject of this video is something is terribly wrong. Why is something terribly wrong? Well, most zoning anomalies in Victoria are small quirks. An outdated overlay here, a mapping error there. What's happened here at 7 Cullen Court, Spotswood, is not a small quirk. It's a planning contradiction so stark that it shakes confidence in the integrity of the zoning framework itself. Standing here in a residential neighbourhood, and the land behind me is zoned TRZ2. Right, so main property is residential, all the rest of the houses are residential. The trailer yard is zoned TRZ2 as a major and NRZ5 as a minor zoning. Of course, at the back we've got the Department of Transport. Their property is zoned TRZ2, and we've got 641 Melbourne Road just over here. That's also zoned TRZ2. NRZ5 is neighbourhood residential. Neighbourhood residential is a policy environment designed to protect low density, community focused housing, residential housing. NRZ5 sets strict limits on what can be built and what activities can occur. Yet right here at the end of this calm residential street lies a single parcel, my mother's property, marked not as residential as the overarching zone, but as TRZ2. Transport Zone 2 Principal Road Network. Now, TRZ2 is intended for land actively facilitating Victoria's transport network. Road reserves, depots, transport yards, arterial corridors and so on. TRZ2 is not meant for private residential allotments, and yet here it sits, fully privately owned, unencumbered and surrounded on all sides by a neighbourhood residential zone, except for at the back and the side over here. So this is not just strange, it's fundamentally at odds with the stated purpose of TRZ2 under the VPP, which is the Victorian Planning Provisions. And what are the implications of this, Clark? All right, we need to talk about the implications of this, right? Because I don't like getting involved in politics, and yet here I am involved in politics. So the clash between NRZ5 surrounds, so that's the neighbourhood, and TRZ2 core has a list of rather troubling consequences. Planning scheme inconsistency. So planning schemes are supposed to work holistically. So when a TRZ2 parcel sits inside an NRZ5 area, the intent of both zones is compromised. Let's talk a bit about enforcement contradictions. Hobson's Bay Council. Council compliance officers face a rather impossible task. Enforce TRZ2 rules in a neighbourhood context without undermining NRZ5 protections. Or enforce NRZ5 rules whilst not having the power to do so because TRZ2 is a Department of Transport applied zoning, and TRZ2 is the dominant zoning of my mother's land. Loss of strategic control. TRZ2 governance means council has fewer levers to govern the land use. A lawful transport use can proceed even if locals object and even if council doesn't like it. Zoning governance questions. So there's a 1978 Executive Council, a Gazette item on screen now. There's the Gazette. I dug up this Gazette, and it's actually very important. So this 1978 Executive Council Gazette notice, what they did under the Footscray Council at the time, council discontinued the street and they transferred it into private ownership via this instrument on screen now. This is the instrument which they transferred it into private ownership via. So no public transport purpose has applied since, yet the land at some point was zoned TRZ2. And it was zoned that way without lawful authority. Why is that, Clark? Well, for it to be lawful, there needs to be a consent document from the head of Transport Victoria. All right? And that's required under ministerial directive in the ministerial directive, the form and content of planning schemes. Okay? And no such consent document exists. That's why the TRZ2 zoning is not lawful. It's ultra vires, beyond the powers. Now the real world consequences have built this legal fortress. Because the land is zoned TRZ2 and my use is clearly a transport purpose, okay, trailers, hiring out trailers to people. So I've got existing use rights under section 6.3 of the Planning and Environment Act of 1987. Now this means that no planning permit is required, no council veto. I've got full legal defensibility against government overreach. So this isn't an exploit, it's simply the lawful result of the planning scheme's own wording. But it highlights just how mismatched the zoning is with its surroundings and how weak the clause relevant transport manager consent gateway becomes when no permit is being sought. Remember, I'm not seeking a permit for this. I'm not applying for a permit, and I've told council that I won't be applying for a permit. I'm just not going to do it. All right? So there's no legal permit pathway because of the ultra vires zoning. So this is a system error hiding in plain sight. If TRZ2 can be applied like this deep inside a residential zone on privately owned land without any active state managed transport purpose, then the system is vulnerable to the exact kind of activation that I've undertaken. Remember, I haven't changed the use, I've merely activated it. So this is my test case. All right? This test case I believe is important and it's got statewide ramifications. I care about the integrity of the planning scheme. By activating the site, activating it, trailers, trailer hire, I force the issue out into the open. I force it into the public eye, into council and the Department of Transport's visibility. Now here's the uncomfortable truth. If I can do it, other people can do it as well. Now obviously we can't have a situation like this persist as it undermines the integrity of the planning scheme. So this is why the Department of Transport and Council is going to want to close these loopholes. The rules need to be updated and improved so we never have another 7 Cullen Court situation ever again. Now I will work with the authorities for as long as it takes to fix these underlying issues. Now the call for accountability. The fix is not about getting rid of lawful uses like mine. It's about aligning zoning with reality. And what does that mean? That means investigating why my mother's land was zoned TRZ2 in the first place. Why is it zoned TRZ2? Now, I've submitted Freedom of Information requests to the Department of Transport to find out exactly that. Why is it zoned TRZ2? When was it zoned TRZ2? Who zoned it TRZ2? And so on and so forth. Accountability, it's about correcting the ultra vires zoning application of TRZ2 to the property. Department of Transport, in consultation with Council and probably the Minister for Planning, will need to do that. Correct the zoning, get rid of TRZ2. Reviewing all privately owned TRZ2 parcels in Victoria, that's going to need to happen for similar anomalies, and making sure that where TRZ2 is applied to private property, that the required consent document from the Head of Transport Victoria is present to ensure that the zoning is legal. Creating clear policy procedures, clear policy protections, so that councils have a clear and legal enforcement pathway where TRZ2 has been applied to private property and where the owner has activated the property under existing use rights, even if the required consent document from the Head of Transport Victoria is missing. So until then, 7 Cullen Court remains living proof that something is terribly wrong in Victoria's zoning governance.